This is a summary of Part 1 of the Retirement Benefits Act. Part 1 of the Kenyan Retirement Benefits Act of 1997 revised in 2022, labeled Part 1, Preliminary, establishes the foundational elements of the Act, including its title and definitions of key terms. These definitions are crucial for understanding the Act's scope and application throughout its subsequent parts. Section 1. Short title. This section establishes the Act's official title as the Retirement Benefits Act. Section 2. Interpretation. This section provides specific definitions for various terms used throughout the Act. These definitions ensure clarity and consistency in interpreting and applying the Act's provisions. Some notable definitions include: Actuary is defined as a person holding specific professional qualifications from recognized actuarial bodies globally, such as the Institute of Actuaries in England, the Faculty of Actuaries in Scotland, the Canadian Institute of Actuaries, etc. This definition ensures that actuarial services related to retirement benefit schemes are performed by qualified professionals. Administrator refers to an individual appointed by trustees to manage a retirement benefit scheme according to the terms outlined in their appointment instrument. This definition clarifies the role and responsibilities of scheme administrators. Authority refers to the Retirement Benefits Authority, a central body established by the Act, specifically in Section 3. This definition establishes a shorthand for referring to this key entity throughout the Act. Custodian is defined as a company responsible for the safekeeping of funds, securities, and documents related to retirement benefits scheme assets. This definition highlights the importance of secure asset custody within the framework of the Act. Retirement benefits scheme encompasses any arrangement, excluding life insurance contracts, that provides benefits like payments or post-retirement medical coverage based on factors like age, length of service, or earnings. This definition establishes the scope of retirement schemes covered by the Act. Scheme fund refers to the specific fund established for each retirement benefit scheme, into which contributions and other monies are paid. This definition emphasizes the segregation of scheme funds from other financial resources. Sponsor refers to the entity that establishes a retirement benefit scheme. Trustee includes both individuals and trust corporations entrusted with managing a scheme's fund. This definition clarifies the fiduciary responsibilities associated with overseeing retirement benefit schemes. By clearly defining these and other crucial terms in Part 1, the Retirement Benefits Act lays a solid foundation for understanding the subsequent sections and their implications for establishing, managing, and regulating retirement benefits schemes in Kenya. This is a summary of Part 2 of the Retirement Benefits Act. Part 2 of the Kenyan Retirement Benefits Act of 1997, titled Part 2, The Retirement Benefits Authority, focuses on establishing and outlining the roles, responsibilities, and operational framework of the Retirement Benefits Authority, RBA. This authority plays a pivotal role in regulating and overseeing the retirement benefit sector in Kenya. RBA's establishment and functions. Establishment, Sections 3 and 4. The Act establishes the RBA as a body corporate with perpetual succession, headquartered in Nairobi. This legal framework empowers the RBA to operate independently, manage its affairs, own property, and engage in legal proceedings. Core objectives and functions, Sections 5 and 17. The RBA's primary objectives are to regulate and supervise retirement benefit schemes, safeguard the interests of scheme members and sponsors, and foster the development of the retirement benefit sector. It also provides advice to the Minister on national policies related to retirement benefits. RBA's powers and authority. Investigative powers, Sections 5A and 5B. The RBA possesses robust investigative powers, enabling it to examine potential violations of the Act and ensure compliance within the retirement benefit sector. The RBA can also assist other regulatory bodies, both domestic and international, in investigations related to breaches of financial regulations. Board of Directors, Section 6. The Act establishes a board of directors responsible for the RBA's management. The board consists of individuals with expertise in finance, insurance, law, actuarial studies, and the administration of scheme funds. This composition ensures that the RBA's leadership possesses the necessary knowledge and experience to effectively oversee the retirement benefit sector. Board powers and responsibilities, Sections 7, 8, 9 and 28. The board holds comprehensive powers to manage the RBA's assets, determine expenditure, receive grants and donations, and invest funds. It also regulates its own procedures and can delegate specific powers and functions to committees or individuals within the RBA. Financial provisions and accountability. Retirement Benefits Levy, Section 16. The Act empowers the Minister, in consultation with the RBA, to impose a levy on contributions made to retirement benefits schemes, the assets of these schemes, or another determined base. The levy provides funding for the RBA's operations. Retirement Benefits Authority Fund, Sections 17 and 18. The Act establishes the Retirement Benefits Authority Fund to manage the RBA's finances. This fund receives proceeds from the levy, investment income, grants from Parliament, and donations. The Act outlines specific guidelines for investing these funds, prioritizing secure and profitable investment options to ensure the RBA's financial sustainability. Financial Reporting and Audit, Sections 19, 20 and 21. The Act emphasizes transparency and accountability by requiring the RBA to maintain proper financial records, prepare annual estimates of revenue and expenditure, and undergo independent audits by the Auditor General. These measures ensure that the RBA operates within a framework of financial prudence and transparency. Part 2 of the Retirement Benefits Act lays a strong foundation for the RBA, outlining its powers and responsibilities as the regulatory authority for Kenya's retirement benefit sector. The Act emphasizes the RBA's role in supervising schemes, protecting members' and sponsors' interests, and fostering the sector's development. This is a summary of Part 3 of the Retirement Benefits Act. Part 3 of the Kenyan Retirement Benefits Act of 1997, titled Part 3, Registration of Retirement Benefits Schemes, Managers, Custodians, and Administrators, outlines the requirements for registering various entities involved in the retirement benefit sector in Kenya. This registration process is mandatory and ensures that these entities operate within a regulatory framework that protects the interests of scheme members and sponsors. Registration requirements. Mandatory registration, Section 22. The Act mandates that all retirement benefit schemes, managers, corporate trustees, custodians, and administrators must be registered with the RBA. Operating without registration is an offense punishable by law. The RBA is required to publish a list of all registered entities annually to maintain transparency. Suitability criteria, Section 22A. When evaluating applications, the RBA considers factors such as financial stability, qualifications, experience, reputation, character, integrity, and compliance history. This rigorous assessment ensures that only entities deemed fit and proper are granted registration. Specific requirements for schemes, Section 24. To be registered, retirement benefit schemes, except those established by law, must be established under an irrevocable trust and have rules that protect the rights and interests of sponsors and members. Specific requirements for managers and custodians, Sections 25 and 25A. Applicants for registration as managers must meet several requirements, including being incorporated as limited liability companies, having a defined minimum paid-up share capital, demonstrating professional capacity to manage scheme funds, and having a clean track record. Similarly, custodians must also be incorporated, demonstrate the capacity to safeguard scheme assets, and maintain a clean operational history. Specific requirements for administrators, Section 25B. Scheme administrator applicants must also be incorporated as limited liability companies with a stipulated minimum paid-up share capital. The Act further mandates that they have the professional and technical expertise to manage scheme administration effectively. Additionally, a certain percentage of their share capital should be owned by Kenyan citizens, unless they are banks or insurance companies. Specific requirements for corporate trustees, Section 25C. Corporate trustees, like other entities, must meet specific criteria for registration, including having a prescribed minimum paid-up share capital and being able to meet their obligations to members and sponsors as defined by the scheme rules. They should also demonstrate the professional capability and have systems in place to carry out their duties. Trustee requirements, Section 26. The Act lays out specific requirements for individuals acting as trustees for scheme funds. They should not have a criminal history, should not be bankrupt, and must meet any guidelines set by the RBA. Notably, their appointment is subject to approval by the RBA. Registration procedure. Application process, Section 23. Entities seeking registration must submit an application to the RBA's Chief Executive Officer, using the prescribed form and paying the required fee. The RBA may request additional information during the application review process. Issuance of certificate, Section 23. After reviewing the application and ensuring all requirements are met, the RBA issues a certificate of registration, authorizing the entity to operate. This certificate may have specific conditions outlined by the RBA. Refusal of registration, Section 27. The RBA has the authority to deny registration if the applicant provides false information or does not satisfy the specified requirements. If registration is denied, the RBA must inform the applicant in writing, stating the reasons for the refusal. Deregistration, Section 28. Grounds for deregistration. The RBA can deregister a scheme or an entity providing services to a scheme if it finds that false information was provided during the registration process, if the scheme is wound up, or if there is a breach of the Act's provisions, regulations, or registration conditions. Notice and representation. Before deregistering an entity, the RBA is required to provide a notice period of at least 28 days, during which the concerned entity can submit a representation. Protection of member claims. The deregistration of a scheme does not impact the claims of its members. If a deregistered scheme has insufficient assets to meet its obligations, the RBA's Chief Executive Officer can oversee the distribution of assets and scheme supervision to protect member interests. Certificate duration and renewal, Section 29. Scheme certificates. Certificates for retirement benefit schemes remain valid until the scheme is deregistered or wound up. Manager, custodian, and administrator certificates. Certificates for managers, custodians, and administrators are generally valid indefinitely unless suspended or revoked. However, these entities are required to pay an annual fee, submit audited financial statements, and inform the RBA of any changes in shareholding or management. Register of Registered Entities, Sections 30 and 31. Maintenance of register. The RBA maintains a register of all registered schemes, managers, custodians, and administrators. This register is open for public inspection, subject to a fee. Evidentiary value of register. The information contained in the register serves as prima facie evidence in legal proceedings regarding the registration status of schemes and related entities. Part 3 of the Act establishes a robust registration framework for entities operating within the Kenyan retirement benefits sector. By outlining clear requirements and procedures for registration, deregistration, and ongoing compliance, the Act aims to ensure transparency, accountability, and the protection of the rights and interests of scheme members and sponsors. This is a summary of Part 4 of the Retirement Benefits Act. Part 4 of the Kenyan Retirement Benefits Act of 1997, titled Part 4 Regulation and Supervision of Retirement Benefits Schemes, outlines the rules governing the operation and management of retirement benefit schemes in Kenya. It focuses on ensuring the financial health of these schemes, protecting the interests of members, and setting standards for transparency and accountability. Management and protection of scheme funds. Scheme funds, Section 32. The Act mandates the establishment of a separate scheme fund for every scheme, except those funded by the Consolidated Fund. This fund serves as the repository for all contributions, investment income, and other scheme-related monies. The segregation of funds safeguards members' savings and ensures they are used solely for their intended purpose. Additionally, the minister is empowered to establish regulations for managing and transferring scheme funds, reinforcing the regulatory oversight of the retirement benefit sector. Statutory contributions, Section 33. The Act allows employers, with the consent of their employees, to channel statutory contributions, those mandated by other laws, into designated scheme funds. This provision offers flexibility in managing retirement contributions while upholding the obligation to contribute to retirement savings. Protection against attachment, Section 36. This Act provides crucial legal protection for retirement savings by shielding them from attachment or seizure. Even in cases of judgments or bankruptcy proceedings against a scheme member, creditors cannot claim the member's contributions or scheme funds, safeguarding retirement savings from external financial pressures. Treatment of death benefits, Section 36A. In line with protecting members' interests, this Act clarifies the handling of death benefits. Upon a member's death, the benefits payable are not considered part of their estate for administrative purposes and are to be paid directly to beneficiaries as designated by the scheme rules, streamlining the process and ensuring that beneficiaries receive their entitled benefits without unnecessary legal hurdles. Reporting and disclosure requirements. Annual reporting and audits, Section 34. This section mandates a high level of transparency and accountability for retirement benefit schemes. Trustees are required to maintain proper financial records and prepare annual accounts, including a statement of assets and liabilities, income and expenditure, and other prescribed documents. These accounts must be audited by an independent auditor appointed with the RBA's approval, ensuring an objective assessment of the scheme's financial position. The audited accounts are then submitted to the RBA, further strengthening regulatory oversight. Failure to comply with these reporting requirements carries significant penalties, highlighting their importance. Actuarial evaluations, Section 35. To assess the long-term sustainability of retirement benefits schemes, this Act grants the RBA the authority to require actuarial evaluations of specific schemes. The actuarial report, prepared by an actuary approved by the RBA, assesses the scheme's financial health and its ability to meet its future obligations to members. This proactive measure allows for adjustments and corrective actions to be taken to ensure the scheme's long-term viability. Similar to annual audits, failing to submit actuarial reports on time can result in penalties. Investment guidelines and restrictions. Investment of scheme funds, Section 37. This Act recognizes the importance of investment returns for growing retirement savings. It mandates that each scheme must have a prudent investment policy that aims to preserve capital and generate competitive market returns. The policy implementation, however, is subject to regulations set by the Minister in consultation with the RBA. These regulations provide a framework for investment decisions and ensure they align with the overall objective of safeguarding members' savings. The Act also includes specific investment limitations for smaller schemes to manage risk appropriately. Restriction on use of scheme funds, Section 38. This section imposes strict limitations on the use of scheme funds, primarily to prevent conflicts of interest and protect the interests of scheme members. It expressly prohibits using scheme funds for direct or indirect loans to any party, including sponsors, trustees, or managers. It also prohibits investing scheme funds in a manner that would benefit these parties at the expense of members. Any violation of these restrictions can lead to disqualification from managing scheme funds. However, recognizing the need for members to access funds for specific purposes, the Act does allow for a prescribed portion of member benefits to be used as collateral for mortgages or housing purchases under specific conditions and regulations. Addressing unsafe practices. Unsafe and unsound practices, Section 39. To address potential mismanagement, this Act empowers the RBA to intervene in cases where a trustee, manager, custodian, or administrator engages in practices deemed detrimental to the scheme. If the RBA's Chief Executive Officer identifies any actions that threaten the scheme's stability or members' interests, they can issue a directive to halt those activities. Failure to comply with such a directive is considered an offense and carries penalties. General Obligations of Trustees and Managers, Section 40. This Act lays out the fundamental duties and responsibilities of those entrusted with managing retirement benefit schemes. Trustees, managers, custodians, and administrators are obligated to manage the scheme in accordance with the Act, regulations, scheme rules, and directives from the RBA. They are also responsible for acting in the best interests of scheme members and sponsors, ensuring prudent financial management, and reporting any issues that may jeopardize the scheme's health. By addressing key aspects of scheme fund management, reporting requirements, investment guidelines, and measures to curb unsafe practices, Part 4 of the Act provides a comprehensive framework for regulating and supervising retirement benefits schemes in Kenya. It underscores the commitment to protecting members' savings, promoting transparency and accountability, and ensuring the long-term viability of the retirement benefits system. This is a summary of Part 5 of the Retirement Benefits Act. Part 5 of the Kenyan Retirement Benefits Act of 1997, titled Part 5, of Inspection and Appointment of Interim Administration, focuses on the Retirement Benefits Authority's (RBA) power to inspect schemes and intervene in situations where mismanagement or illegal activities are suspected. Inspection Powers and Procedures, Sections 41 to 43. The Act grants the RBA broad authority to inspect retirement benefit schemes. The Chief Executive Officer, CEO, can initiate inspections at any time and is obligated to do so if directed by the board. Inspections can cover any aspect of a scheme's operations, including the activities of managers, corporate trustees, custodians, and administrators. Inspectors are equipped with significant powers to compel cooperation. They can access all books, accounts, records, and other relevant documents. Failure to comply with an inspector's request for information is a criminal offense. The Act includes provisions to protect the confidentiality of information obtained during inspections. Following an inspection, the inspector submits a report to the CEO. This report highlights any breaches of the Act, instances of mismanagement, or any other issues that require attention. Directions to Scheme Management, Section 44. Based on the inspection report, the CEO can issue binding directives to the scheme's trustees, managers, custodians, or administrators. These directives aim to rectify the identified issues and ensure compliance with the Act. Sharing information, Section 44A. Recognizing the importance of interagency collaboration, the Act allows the RBA to share information with other regulatory bodies. This provision is essential for maintaining the integrity of the financial sector and preventing cross-sector misconduct. Appointment of interim administrator, Section 45. In more serious cases where the scheme's stability or members' interests are significantly threatened, the RBA can appoint an interim administrator. This drastic step is usually taken when less intrusive measures, such as directives, are deemed insufficient. Several circumstances can trigger the appointment of an interim administrator. These include a failure to submit annual accounts, submission of false or misleading information, or any other situation where the CEO believes intervention is necessary. Powers and responsibilities of the interim administrator, Sections 45. The interim administrator assumes control over the scheme's management, effectively superseding the existing trustees, managers, custodians, or administrators. They are granted the authority to make decisions and take actions necessary to stabilize the scheme. The CEO, with the approval of the authority, may also remove specific officers or employees of the scheme if they believe those individuals have contributed to the problems. The interim administrator's responsibilities are comprehensive. They include securing the scheme's assets, recovering debts, evaluating the scheme's financial health, assessing compliance with the Act, recommending restructuring if needed, gathering information from previous management. Within 12 months, the interim administrator submits a report to the CEO. This report assesses the scheme's viability and recommends whether it should be revived or deregistered. The CEO reviews the report and makes recommendations to the board, which then decides the scheme's fate. Protection from liability, Section 45. The Act provides legal protection to the CEO, the interim administrator, and other individuals involved in the intervention process, as long as they acted in good faith. This provision is crucial to ensure that individuals are not deterred from taking necessary actions due to fear of personal liability. Treatment of unclaimed benefits, Section 45A. This section addresses the handling of benefits when a scheme is wound up but members cannot be located. After 2 years, any unclaimed benefits are classified as unclaimed assets under the Unclaimed Financial Assets Act of 2011. This process ensures that these funds are managed appropriately and can potentially be reunited with their rightful owners. In essence, Part 5 of the Retirement Benefits Act provides a framework for regulatory oversight and intervention in the management of retirement benefit schemes. It empowers the RBA to protect the interests of scheme members and sponsors by ensuring compliance with the law and addressing situations where mismanagement or malfeasance is suspected. The Act strikes a balance between providing schemes with operational autonomy and establishing a robust regulatory framework to protect the integrity of the retirement benefits system. This is a summary of Part 6 of the Retirement Benefits Act. Part 6 of the Kenyan Retirement Benefits Act of 1997, titled Part 6 Appeals, outlines the avenues for recourse available to individuals and entities dissatisfied with decisions made by the Retirement Benefits Authority, RBA, or other parties involved in the administration of retirement benefit schemes. It establishes a two-tiered appeal process, allowing for initial review by the RBA's Chief Executive Officer, CEO, and, if necessary, a subsequent appeal to a dedicated appeals tribunal. Appeals to the Chief Executive Officer, Section 46. This section provides a direct line of appeal for scheme members who disagree with decisions made by those responsible for their scheme. This includes decisions made by managers, administrators, custodians, or the trustees. The Act intends this process to be a less formal way to address grievances and potentially resolve them quickly. Members seeking a review must submit a written request to the CEO. This request should clearly outline the decision being challenged and the grounds for dissatisfaction. To ensure transparency, a copy of the request must also be served to the party whose decision is under review, the manager, administrator, custodian, or trustees. Establishment of the Appeals Tribunal, Section 47. Recognizing that some disputes may require a more formal adjudication process, the Act establishes a dedicated appeals tribunal. The Minister for Finance appoints the tribunal members, a chairman and 4 other members, who serve for 3-year terms. The chairman must be an advocate of the High Court of Kenya with at least 7 years of experience, ensuring a certain level of legal expertise within the tribunal. To ensure efficiency in the appeals process, the Act specifies a quorum for the tribunal. For a hearing to proceed, the chairman and at least 2 other members must be present. Decisions are made by majority vote, and in cases of a tie, the chairman holds the deciding vote. Appeals to the Tribunal, Section 48. Individuals or entities dissatisfied with the ABA's decisions have a right to appeal to the tribunal. This includes decisions made by the authority itself or by the CEO in their capacity. The grounds for appeal can include decisions related to registration, deregistration, investment guidelines, or any other matter under the Act or its accompanying regulations. The Act also allows either party involved in a dispute with the ABA to appeal to the tribunal. This provision ensures that both the regulated entities and the regulator have an equal opportunity to seek a binding resolution from an independent body. Powers of the Appeals Tribunal, Section 49. To effectively adjudicate appeals, the tribunal is granted significant powers comparable to those of a subordinate court. It can summon witnesses, administer oaths, compel the production of documents, and admit evidence. The tribunal is not strictly bound by traditional rules of evidence and can consider any information it deems relevant to the case. The tribunal also has the authority to award costs associated with the proceedings. It can determine the amount and direct the responsible party to pay those costs. This provision helps deter frivolous appeals and ensures that parties who incur expenses due to others' actions can seek reimbursement. Procedures and Evidence, Sections 49 and 50. To streamline proceedings, the tribunal can accept evidence in the form of affidavits and administer interrogatories, which are written questions requiring written answers under oath. This allows for a more efficient collection of information, particularly when dealing with complex financial matters. Failure to comply with a summons or provide truthful information to the tribunal is a criminal offense, punishable by fines or imprisonment. This underlines the seriousness of the tribunal's proceedings and the importance of cooperation from all parties involved. Enforcement of costs, Section 51. The Act outlines a clear process for enforcing the tribunal's decisions regarding costs. The party awarded costs receives a certificate from the tribunal, which can be filed with the High Court. Once filed, this certificate has the weight of a High Court decree and can be enforced accordingly. This linkage to the High Court significantly strengthens the tribunal's authority. Rules for Appeals, Section 52. The Chief Justice of Kenya is empowered to establish specific rules governing appeals to the tribunal. These rules can cover aspects such as filing procedures, fees, the scale of costs, and notification procedures. Until these rules are established, the provisions of the Civil Procedure Act apply, providing a framework for conducting appeals in a structured and legally sound manner. In summary, Part 6 of the Retirement Benefits Act establishes a robust and fair system for addressing disputes and grievances related to retirement benefit schemes in Kenya. By providing both informal and formal avenues for appeal and by empowering the appeals tribunal with significant authority, the Act aims to ensure transparency, accountability, and the protection of all stakeholders' rights within the retirement benefit sector. This is a summary of Part 7 of the Retirement Benefits Act. Part 7 of the Kenyan Retirement Benefits Act of 1997, titled Part 7, Miscellaneous, serves as a catch-all for various provisions that don't neatly fit into the preceding sections of the Act. This part covers a range of topics, including general penalties, debt recovery processes, clarification of legal liability, regulations and guidelines, transitional arrangements, and exemptions. General penalty, Section 53. This section establishes a general penalty for violations of the Act where a specific penalty isn't outlined elsewhere. This ensures that all breaches of the Act's provisions have consequences. The penalty for such offences is a fine not exceeding 100,000 shillings, imprisonment for up to 1 year, or both. This provides flexibility for the courts to impose penalties proportionate to the severity of the offense. The Act recognizes that there may be situations where an individual is not directly responsible for an offense but is implicated due to their position within an organization or their relationship with the actual offender. A person can avoid liability if they can prove to the court's satisfaction that the offense occurred without their knowledge, consent, or involvement and that they took reasonable steps to prevent it. Proceedings for recovery of deductions from employers, Section 53A. This section outlines the process for recovering employee contributions that an employer has deducted from wages but failed to remit to the retirement benefit scheme. This provision is crucial for protecting the financial security of employees and the integrity of the retirement savings system. If an employer fails to remit deducted contributions within 15 days, the scheme can initiate legal proceedings to recover the funds. Before taking legal action, the scheme must provide the employer with at least 7 days written notice. The written notice must demand payment within 7 days and inform the employer that failure to comply will result in court action. A copy of this notice must also be sent to the RBA, ensuring regulatory awareness and potential intervention. Any sum recovered through this process is subject to a 3% monthly compound interest, payable to the scheme. This incentivizes prompt payment and compensates the scheme for lost investment earnings. Non-compliance with the notice, even if the debt is eventually settled in court, is a separate offense. This underscores the seriousness of timely remittance and aims to deter employers from delaying payments. Powers to recover unremitted contributions, Section 53B. This section grants the RBA additional powers to address instances where employers fail to remit contributions. This provision strengthens the Act's enforcement mechanisms and provides a clear course of action for recovering unpaid funds. When an employer fails to remit contributions, the RBA can demand immediate full payment of all contributions, accrued interest, and a penalty. The penalty is either 5% of the unremitted amount or 20,000 shillings, whichever is higher. This penalty structure aims to disincentivize non-compliance, especially for larger sums. Alternatively, the RBA can direct the employer to submit a remedial plan outlining how and when they will offset the accumulated contributions and interest. This offers a degree of flexibility for employers facing genuine financial difficulties while still holding them accountable for fulfilling their obligations. In cases of persistent non-compliance, the RBA can bar the employer from making further deductions from employees' salaries. This measure protects employees from having their wages deducted without those funds reaching their retirement accounts. The RBA can lift this order if satisfied that the employer can meet their obligations. Offences by corporate bodies, partnerships, principals, and employees, Section 54. This section clarifies the attribution of criminal liability for offences under the Act. This is particularly relevant when offenses are committed by entities rather than individuals. When a corporation commits an offense, individual directors and officers can be held personally liable if they knew or should have known about the offense and didn't take steps to prevent it. This provision aims to prevent individuals from using the corporate veil to shield themselves from accountability. Similarly, in partnerships, partners and officers with knowledge of offenses can be held liable. The Act underscores the principle that responsibility ultimately rests with individuals, even within complex organizational structures. Conduct of prosecutions, Section 54A. This section clarifies the legal framework for prosecuting offenses under the Act. This ensures consistency and adherence to due process in enforcing the law. The Attorney General can appoint public prosecutors specifically for cases arising under the Retirement Benefits Act. This allows for specialized expertise in handling these cases, potentially leading to more effective prosecution. The Act explicitly designates the RBA as a public authority for the purposes of criminal procedure. This designation confers upon the RBA certain rights and powers within the criminal justice system, enabling them to play a more active role in prosecuting offenses related to the Act. Regulations, Section 55. This section empowers the Minister for Finance, in consultation with the RBA, to make regulations for the better implementation of the Act. This provides a mechanism to adapt the Act to evolving circumstances and address unforeseen issues. The scope of these regulations is broad. It includes, but is not limited to, prescribing procedures for registration, outlining membership eligibility criteria, defining the nature of benefits, setting fees payable to the RBA, and establishing guidelines for winding up schemes. Exemption from Cap 446, Section 56. This section exempts the RBA from the provisions of the State Corporations Act, Cap 446. This exclusion provides the RBA with a degree of autonomy and flexibility in its operations, differentiating it from typical state-owned enterprises. This special status reflects the RBA's unique role as a regulator rather than a commercial entity. Transitional Provisions, Section 57. This section outlines the requirements for existing schemes and their administrators to transition smoothly into the framework established by the new Act. This ensures continuity and a reasonable timeframe for compliance. Existing trustees and managers had 60 days from the commencement of the Act to apply for registration under the new rules. However, the Minister, in consultation with the RBA, could extend this period for up to 3 years. This provision recognizes that adapting to a new regulatory framework takes time and allows for a phased implementation approach. Supersession, Section 58. This section asserts the primacy of the Retirement Benefits Act over any conflicting provisions in other legislation, except for the Constitution of Kenya. This clarifies the Act's legal standing and ensures that its provisions take precedence in matters related to retirement benefits. Exemption from compliance with provisions of this Act, Section 59. While the Act is generally applicable, this section allows the Minister, through a Gazette notice, to grant exemptions from specific provisions to certain individuals or categories of people. This flexibility allows for unique circumstances to be addressed on a case-by-case basis without undermining the overall objectives of the Act. Importantly, the Act makes it clear that no exemptions are permissible when it comes to the payment of retirement benefits or any provision within Part 3 of the Act. This safeguard ensures that the core objective of protecting retirement savings is not compromised.